Hello, hello, and welcome back to the University. Today we have a quick one. It's the next two parts of the Raymond Davis saga. We start with March 18th. COVID is officially a thing now, and what do you know? Raymond Davis is sick. Imagine that. Then we move to April 20th, and we have an official motion for OR release based on the COVID-19 issues. Go figure. All right, let me know what you think in the comments. Hope you enjoy.
All right.
Page.
This is page 7. All right. So.
This is Ms. Collins, Judge.
So we did the motion to dismiss counsel. I don't know if.
She's necessary?
Yeah. So this is page 7, C-342-946-1, State of Nevada versus Raymond Tyrone Davis. This is a motion to dismiss counsel. Mr. Davis is present in custody. Mr. Maynard on his behalf, who also works with Mr. Mueller. Before we get started, I just wanted to put a few things on the record. So last time we were here, Mr. Davis had explained to me, as well as Mr. Mueller, about some health issues that Mr. Davis was having. After court, we reached out to the jail to discuss what was going on with Mr. Davis, what else needed to be done to make sure he was getting the proper care. They explained to me that they were doing what they were supposed to be doing for Mr. Davis, but that they would not be willing to share any of that with me because of HIPAA. So they were speaking with my law clerk. So, like I said, they advised that they were doing everything that needed to be done for your health, Mr. Davis, but and I understand that, right? And we didn't ask them to give us any specifics about your health. We just wanted to make sure. Mr. Davis says he's having these issues. We just want to make sure that they're being taken care of by the jail. Mr. Mueller and Mr. Davis knew that we were going to do that. And Mr. Mueller checked back with me last week saying, hey, did you guys ever get in touch with them? And we sent in an email, yes, we reached out to the jail. We wanted to make sure that Mr. Davis was getting the appropriate health care, and they assured us that he was, but they would not be willing to give us any specifics, which obviously I recognize. Yes?
Your Honor, it wasn't giving me the proper health care. I passed out on March the 2nd. I collapsed and was rushed to the medical unit. My blood pressure was like 200 at heart attack level and stroke level. They said they need to get me out of here. They said they would rush to get me out of the hospital. They haven't. They took me back to the unit. I've been sick and in my bed every day since. I'm peeing more blood out of my urine, more blood. I'm in more pain, and I'm in worse condition. It's a doctor that's in jail next to me, bed 52, Derek Oning. He said, you're going to die. He said, you're not getting medical attention, you're going to die. And then they sent some nurse up here, and the other day, said, no, it's not looking good. You need to be in the hospital. A nurse. I don't know why they won't release it to you. I've told them they can release everything they wanted to jail. No problem. They won't. They said, with your immune system down,
I'm sorry to interrupt, Your Honor. Erica Ballou, the Clark County Public Defender's Office, WellPass now takes care of the medical at the jail as opposed to NAFCare, who used to give like just generic releases. WellPass won't even use our generic release. They will not give medical to anyone without the specific medical release that they have. We've got it in our office. I don't have any copies in court with me, but if somebody from Mr. Mueller's office wants to reach out to me, Jay, you can email me, and I can email that to you today, and you can get the information. I'm just saying that I know for a fact that they will not release anything to anybody from WellPass. So sorry to interrupt.
No, that's okay. And I don't even need I don't want the records because I think that's
I'm saying
Mr.
Mueller's
Davis' rights, but Mr. Mueller's office should probably get them.
We will, absolutely. I'll get hold of Ms. Blue.
Okay.
Right after.
All right. So let's talk about your most recent motion to dismiss counsel, Mr. Davis.
Yes, I want to remove counsel. Want me to read it?
No, I read it. But is there anything you'd like to add?
Well, basically, February the 17th in your court, you told me you asked Mr. Mueller to come and see me. Mr. Mueller has never came to see me. It's 2 months later. Over 2 months later, I have little to no contact with. I have absolutely no contact with my attorney, other than if I see him in court 2-3 minutes. But other than that, he refused to see me. He refused to do anything to my benefit. Even with the Supreme Court, he refused to give me paperwork for him. I reached out to the Supreme Court. They sent me a big pile of stuff. It's just, it's really hard to have a case like this when no one is helping you. I have been trying to get rid of Mr. Mueller since December the 16th. We are now 4 months past, and I still can't get rid of him. I don't know why I cannot remove attorney that I paid for. It's not a state appointed. It's not a public defender. I paid over $15,000 out of my pocket, and I have got 20 minutes worth of visitations and about 5 minutes worth of phone call conversations in the 5 months that I have had him. That is ineffective assistance of counsel at its finest. I am defenseless, and basically that's it. I mean, I can't stand him.
I guess
I don't like him.
what is your suggestion? Because you know you can't represent yourself anymore, and you won't accept an office of appointed counsel.
No.
So.
Yeah, I would like to put in if you deny it, I would like my request to represent myself. If you deny it, I'd like to appeal it to the Supreme Court.
Okay, well, you already did represent yourself. You caused a mistrial, so I explained to you that you do have a right to represent yourself until you don't anymore because of behavior. So if I have denied that, so if you wish to appeal me on that.
If you want to deny this one, I would like to appeal this one. Emergency appeals.
Okay, so I'm denying your motion to dismiss counsel. Mr. Mueller and Mr. Maynard have showed up. They have explained to me on multiple different times that they are working on your case, that they will be prepared to go to trial. Mr. Maynard, I did ask Mr. Mueller to go see Mr. Davis to see if some of these differences could be worked out. He told me that he would. Now, I know these are trying times, right? So I recognize that you might not be able to go to the jail, but I would ask that a conversation be had so that some of his concerns can be dealt with. But I am not allowing Mr. Davis to represent himself. I've said that before, and I will say it again because of the long list of reasons that I have already placed on the record.
I want to appeal this ruling to the Supreme Court immediately, expedited.
Okay. All right. That'll be it. Thank you. Yep.
All right. 7. Moving on to page 7, please. Page 7 is C342946-1, State of Nevada versus Raymond Tyrone Davis. He is present in custody. Mr. Maynard on his behalf. Ms. Collins on behalf of the state. This is a defendant's notice of motion and motion for owner cognizance release based on the changed circumstances brought about by the COVID-19 crisis. Mr. Maynard?
Good morning, Your Honor.
Wait, sorry, I should put on the record. I did have the opportunity to read the pleadings by both sides on this case. Go ahead.
Okay, great, thanks. In that case, I'll try not to rehash them to any significant degree. I would say that Mr. Davis's case is in a fairly unique position here in that obviously writ of mandamus from the Supreme Court is a unique circumstance, or is an unusual circumstance, an unusual measure, and they've frozen the case currently, so he is in a bit of limbo at present. If the Supreme Court does find the same way as they found in Nzunza with Mr. Davis, his case would seem to be dismissed at that time, so the fact that he's currently doing time may very well come to nothing. I understand that the state and the court's concerns are whether or not Mr. Davis is a danger to the community and whether or not he's likely to return for his case, for his court appearances. First of all, and I don't mean to be glib here, but I think that Mr. Davis has made extraordinarily clear his intention to be a part of this case and to fight this case at every front in every way possibly imaginable. So the likelihood that he would not show up, even before the period where he was representing himself, the very few circumstances where we represented him on a matter that didn't require his presence, it was just a procedural matter and we handled it in court, he always wanted to be present. The likelihood of him not returning, I think we all understand to be vanishing. Furthermore, whether or not he's a danger to the community, the state has done diligent work in dredging up pretty much everything that Mr. Davis has ever been accused of, and in all of those accusations, none of them have come from the past 3 years when this case has been technically ongoing, though not to his knowledge. When he received the business card on his door from the police officer when the case was first filed, he happily called him back. There's no accusations that he's been a danger or a threat to the community in this entire time. Furthermore, even these accusations, even taken on their face and taken with all seriousness, there's no violence inherent in these acts. Obviously the crimes are disturbing, obviously the crimes are very serious, and we're not underplaying those, but there was no violence in these accusations as they stand presently. Furthermore, we would say that Mr. Davis is in a unique position, or is in a higher bracket of risk in this particular circumstance. Mr. Davis is clearly aging, and he's in an age bracket that is currently at a higher risk of contracting and of COVID-19 being a very serious condition. Furthermore, as statistics are further coming out, it does appear that African Americans are at a disproportionately high risk of COVID-19 being a more serious condition, more serious ailment, and clearly Mr. Davis is an African American man. So we would say, with all these things considered, the unusual circumstance, the certainty I think everyone has that Mr. Davis will continue to be a part of his case in any appearance that he can possibly show up to. The lack of any kind of violent accusations here, the failure to show any kind of present danger to the community, and furthermore the exceptional risk that Mr. Davis is at, being in CCDC presently, we would say that all this leads to exactly what the Supreme Court was conceiving when they handed down their decision, saying that the least possible restrictive means, especially if it avoids bail, to get defendants out of custody, is the ones that we should go with. We would welcome any restrictions that the court needs to apply to Mr. Davis in order to abate its concerns about his return and danger to the community, but we think that the only appropriate procedure at this time is to release Mr. Davis on his own recognizance.
Thank you. Ms. Collins?
Your Honor, very briefly, the state's been here probably 6 times now to address Mr. Davis's bail status. I understand the Supreme Court has now taken a different view of what my burden is to convince the court that cash bail is appropriate. We've discussed his prior felonies before. We have discussed his dangerousness to this community before, and in a very well-drafted order, this court decided that he was a specific danger to these victims, that he was a specific danger to this prosecutor, that he was unable to control his temper, unable to control his actions. I think he will appear. I just don't think that he can maintain his temper and his civility if you were to release him. I honestly don't. I think he is a danger, and I think he continues to be a danger. This is kind of opportunistic, if you will, for a lot of these defendants to come forward and say, because of COVID-19, I have to be released. That doesn't change what this court should analyze in terms of his prior history, the facts of this case, his previous outbursts and behavior in this courtroom that showed this court that he was dangerous. I think I can show by a clear and convincing standard that this court should maintain the cash bail that he brought to court.
So, we've had these motions on throughout this case. I would say this is probably the 3rd or 4th, maybe even 5th or 6th, I'm not sure, in regards to bail settings. And if you remember, on one of those I ruled in writing, a written decision. It was, I think, 4 to 5 pages in regards to my concerns. And on one side, I agree with you that he is very adamant about wanting to be here and wanting to fight his case, but if you look at my written decision and my order, I go into great detail talking about how many times, at what lengths he went to get that house arrest bracelet for me to allow him to take it off. And it wasn't just he was telling me about the pain, so I said, okay, I will have them move it from one foot to the other foot. And he wouldn't do it. He wouldn't go down. He wanted it off. And he asked continuously over and over and over again. And one of the concerns I discussed in my order was I am only left to guess at why someone would want that house arrest bracelet so badly off. And it brought me a lot of concern when I said I'll take it off the leg that's making it sore and I'll put it on a different leg. But more than that, my safety in regards to the community, the victims, it's very rare that I have a defendant say I went to the hospital because I was afraid of doing either dangerous or bad things. That was very, very worrisome, and so I find that the bail and the amount that I've set is appropriate for the reasons listed in my written order, and I stand by those. And without the ability to alleviate me of my concerns in regards to the danger to the community, the danger to the victims and witnesses, and the danger to this prosecutor, I'm not willing to change my mind at this time, so the defendant's motion is denied.
Thank you.
Thank you. All right, that is it. All right, so we're going to go to 33.